January 23rd, 2026. I want you to hold that date in your head. January 23rd, 2026. Do not let it go. Because this is the date South Africa's top court created a sentence that sounds impossible. Unlawful extradition, but case back on. Deputy Chief Justice Dunstan Malambo read the unanimous judgment in Johannesburg, and it was written by Justice Leona Theron. Now listen to me carefully. Do not half-watch this. If you care about corruption cases, state power, and the kind of power question that can flip a trial, you need every word. And before we start, hit like, subscribe. We are not going to stop digging. This story lives in two places at once: Johannesburg, where the Constitutional Court delivers the judgment, and Bloemfontein, where the Free State High Court becomes the battlefield again. The name at the center is Moroadi Cholota. She was extradited from the United States in August 2024. In 2025, the Free State High Court ruled in her favor on the extradition issue. And now, in January 2026, the Constitutional Court has sent the matter back. According to court papers and reporting, she is accused in the Free State asbestos corruption case, alongside other accused, including former Free State Premier Ace Magashule. Now lock onto the clock, because the asbestos trial is set to resume on Monday, January 26th, 2026. This was supposed to be an asbestos removal project for vulnerable communities, and it turned into an alleged corruption case.
We know that the agreement between the department and the joint venture agreed to pay the joint venture an amount of over 250 million rand. Correct.
Correct.
And then?
We know that there was a further subcontract for most, if not all, of the work to be done for 21 million rand to the Ori Group. We know that. It can hardly be alleged, therefore, that there was value for money in the payment of 250 million rand. Would you accept that?
My answer is possibly the department did not get full value for money. In this sense, I'm not able to say how much.
Yes, okay, all right.
Once again, it gets worse.
So this judgment did not land in a vacuum. It landed right before court day. The headline says, the court agreed the extradition was unlawful, but still sent the matter back and kept the prosecution alive.
It's a great judgment for us. It's legally sound, because it's a vindication of our long-held view that the fact that you are challenging the unlawfulness of the extradition order should not fail to engage the jurisdiction of the court.
Read it again. Unlawful extradition. But the case goes back. Those are the two words that should not coexist. Unlawful, back. Now I want you to do something. Stop thinking emotionally for 5 seconds and think mechanically. If an extradition is unlawful, what is supposed to happen next? Does the entire case die? Or does the court say something colder, like, we can fix the process without killing the trial? That is the tension. According to reporting, the NPA calls parts of this judgment a vindication and says the High Court has jurisdiction to hear the criminal matter. Also, Cholota appeals for donations to cover legal fees now at more than R5 million, she says, and she alleges the extradition was driven by malice because she refused to testify against Magashule.
I'm very grateful for the justices of this Constitutional Court for the judgment. We welcome it, of course. As we all heard during the oral testimony on the Free State High Court on how the police officers and the prosecutors conspires to subject me to the cruel treatment and the mental torture, and how they made threats against my liberty and freedom. I think the nation also watched as I was taken away from my university where I was studying, unlawfully brought to this country, chained and accompanied by countless men with guns, and this after I had to spend still time in jail. As you've all watched, I was brought into court shackled, which is something that none of my former accused went through.
And I need you to notice the careful line here. The malice claim is an allegation, not a fact proven in court, so we treat it like a lead, not a verdict. Now we climb the next step, the actual judgment. According to the Constitutional Court's media summary and judgment, the court dealt with who has the authority to make an outgoing extradition request to a foreign state, and what the legal effect is when an extradition was unlawful. Here is the simple version. There is a difference between preparing paperwork and having the legal power to make the request. The court says the NPA can prepare, draft, and submit the extradition request to the national executive, but the national executive is the one that makes that request to a foreign state. In plain terms, prosecutors can draft the request, but the government's executive branch must be the one to formally ask a foreign state. This is not just bureaucracy. An extradition request touches diplomacy and foreign relations. That is why the court places the power with the national executive, not the prosecutors. Now hold on, because here comes the part that makes people angry. The court found her extradition from the U.S. to South Africa was unlawful, but the court also said the fact it was unlawful does not, by itself, deprive the High Court of criminal jurisdiction over her. This is the legal equivalent of saying, yes, the door was opened the wrong way, but you are still in the building, and the building still has rules. The Free State High Court treated the unlawful extradition as a jurisdiction stopper. The result was simple. Her prosecution was halted, and she was released on that ruling. So the Constitutional Court set aside the Free State High Court decision that had effectively stopped her prosecution, and it sent the matter back so the special plea can continue on the remaining issues. According to reporting, the Constitutional Court also found the state's right to be heard was infringed in the High Court, because a new argument was introduced during closing submissions, leaving the state without a fair chance to respond. That is the courtroom version of changing the rules after the buzzer. And the top court is telling the High Court, run that part again properly. This matters because it explains why the top court was willing to overturn what looked like a clean escape route. If a court believes the process was unfair to the state, it is more likely to send it back. Friday, January 23, 2026. Judgment. Monday, January 26, 2026. Court resumes. That is why everyone is talking in victory language, because nobody wants to walk into Monday looking weak. And online, people split into two camps, technicality escape versus process matters. Now look at the bigger chessboard. This judgment was delivered in a set of matters that also involved the Schultz extradition question, and the court used it to clarify authority and stop a domino effect of technicality escapes. And here's the part people miss. In the Schultz matter, the state got burned by time. The court refused condemnation for a 3-month delay.
A Schultz case where Mr. Jonathan Schultz had argued that it is the justice minister who actually has the right to extradite an individual from a different country, not the NPA.
So this was not a clean victory lap. It was a warning. If the rule became any unlawful extradition kills jurisdiction, you would see a wave of challenges. And the court clearly does not want that door wide open. So it draws a line. Yes, the extradition path was flawed, but prosecution can still continue, depending on the broader interests of justice and the remaining legal issues that must be argued properly in the High Court. Now here's the question that keeps me awake. If the law is so clear that the national executive must make the request, how did it get to this point? Was it confusion? Was it habit? Was it urgency? Or was it something else? We do not accuse. We follow incentives. And that takes us to money. I want you to hold this number in your head. R$255 million. According to Zondo Commission-related reporting summaries, the asbestos contract was about R$255 million, and payments were stopped after about R$230 million had already gone out. Now hold this number too, R$230 million. This is not pocket change. This is the kind of number that creates two powerful motives at the same time. Motive 1, delay. The longer a case drags, the more public attention fades. Motive 2, pressure. If someone believes a witness can change the story, that creates incentives people will try to exploit. It raises the possibility of pressure campaigns, alleged by the accused. We cannot confirm the motive. We can only map incentives. Now careful again. We are not saying what happened. We are saying why the stakes make people do things that look irrational from the outside. According to reporting, Cholota alleges the extradition was malicious, and she has raised serious claims about how she was treated. Those claims are not proven facts. They are claims that may become part of what gets argued and tested in court. At the same time, according to reporting, the NPA is framing this as a jurisdiction and fairness issue, saying the High Court should hear the matter and the criminal case should proceed. So what happens next is not a YouTube opinion fight. It is a courtroom fight, and Monday is the arena. Watch what the High Court does first. Does it tackle the special plea immediately, or does it roll straight into the main trial issues? On Monday, the asbestos trial resumes in the Free State High Court, but the special plea around the extradition and the remaining arguments could take center stage first. So if you want to understand this case like an investigator, watch for three things. First, do we see a clean explanation for how the wrong authority made the extradition request in the first place? Second, do we see any concrete evidence offered to support the more explosive allegations, or do those remain allegations without proof? Third, does the court move quickly now, or do we watch delay tactics stretch this into another year, and now we close it the way we should? I am going to leave you with three questions. Question 1. If the power to request extradition belongs to the national executive, who signed off on the process that the court says was unlawful, and when did they realize it was vulnerable? Question 2. If the state says it was not given a fair chance to respond to a late argument, what else was said or introduced late, and who benefits when the process becomes messy? Question 3. With numbers like R255 million and payments described as having run to around R230 million, who has the most to gain from a slow trial and who has the most to lose from a fast one? Now it is your turn. Comment below. Is this a correctable legal mistake that should not derail a corruption case, or is it a warning sign that the system is cutting corners when the stakes get too high? Hit like. Subscribe. We are not going to stop digging, because Monday is not the end of this story. Monday is where the next receipts either appear or disappear.